Court calls matter of Kevin Coates versus Shelley Hill, file 22-7161 DM. This is Mr. Coates' motion regarding an animal. Mr. Coates is in the courtroom. Court calls Shelley Hill. Shelley Hill. No response. Matter scheduled for 9. It is currently 10:38. I did inquire. Actually, Ms. McNady advised me that Ms. Hill has not checked it with the Zoom application, so we shall proceed. Mr. Coates, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Please state your name, sir.
Kevin Coates.
Mr. Coates, I did read your motion, and you were requesting that the pet not be brought to your residence.
Pets also.
You say pets?
Pets.
How many pets?
2.
They both dogs?
Yes, they are.
Dogs' names?
Zeke and Lola.
Lola?
Yep.
Are any of those animals certified service dogs or anything like that?
As far as my knowledge, no.
Okay.
I have not received no paperwork on
All right. Your motion is granted. No appeal. Courtroom. Terry Hornbacher.
them.
This is Terry Schultz on the screen, but Terry Hornbacher appears. I'm sorry, she wasn't pro per. However, the court received. There is no appearance yet in the. Oh, there is. I'm sorry. There's an appearance in the file filed yesterday by Attorney Daniel L. Price, representing the defendant in this case. I'm assuming Ms. Rogenbach, you're ready to proceed, correct?
Your Honor.
And Mr. Price, would you like to make a motion?
Yeah, I'd like to make a motion to adjourn for 2 weeks, Judge. I just got retained, filed like 2 days ago. I filed my appearance yesterday. There's some very, very serious allegations made by plaintiff and to be made by the defendant that would require a fair amount of time of this court to sift through. I'm not prepared to respond yet. I haven't. I will be within the next 6 or 7 days. I can have my responsive pleadings in before the 26th of January. And I request that we adjourn until then. I know that I have made a request to plaintiff's counsel. Essentially, if I don't agree to everything she wants in her motion, she won't agree to adjourn. I'm willing to, and my client is willing to allow a couple of days, a week between now and the 26th for parenting time to be taking place during the day from 11 a.m. to 4 p.m. with a specific pickup by plaintiff of the child at her preschool at 11 a.m. and then dropping the child off at her maternal grandmother's home at 4 p.m. Twice a week. We've got 2 weeks to try to get this done. I'd like to do that. I believe it would be unfair. I know that my client was served a while ago and a fault was entered early this week, but I still believe it would be unfair to force my client to go through this hearing without counsel having been prepared because I was just filed my appearance.
Thank you, Judge. Ms. Schultz, Ms. Hornbacher was served December 5th. Yes, Judge. She was served December 5th. She was defaulted on January 9th. Mr. Price, his good or bad luck, is not the first attorney that's reached out and said he represented her. Ms. Hornbacher has repeatedly through text, because they communicate to my client's father, indicated that her attorney has told her not to allow contact. She has repeated that DHS has told her not to allow contact, that the child's therapist has told her not to allow contact, that the same nurse and the same advocate told her not to allow contact, that the CAC advocate in Huron County told her not to allow contact, that the police told her not to allow contact. DHS did an exhaustive report in the month of October and said everything is unfounded, so much so that the same nurse says she can't believe Ms. Hornbacher is actually a teacher and allowed her own children. That's the mother. My client was an equal participant in raising this child until such time as he decided this relationship was toxic. He's removed himself from the relationship. When he wouldn't come back, she accused him of molesting their daughter. There was an exhaustive investigation for the month of November. The results came from DHS. Ms. Hornbacher demanded a letter from DHS. They provided that letter to Ms. Hornbacher saying there's no findings, there's nothing open, nothing was found, no preponderance. There is no professional involved that thinks Mr. Hornbacher is a detriment to his child. Ms. Hornbacher's position seems to be that if she can't be with the defendant, neither can the child. I'm comfortable with an adjournment if my client has parenting time. Prior to leaving her, he was an equal participant. We provided my client's work schedule. We provided a proposed calendar that gives him about 12 to 14 days a month based on their work schedules, where when the child's not in school, she would be with her dad. which is the goal of the court, to have healthy relationship with both parents. I cannot express enough how difficult it is to ask for this. When I spoke to the child's therapist, she is requesting, and I know it doesn't happen a lot in this court, that a GAL.
I would object, Judge. I would object to the witnesses hearsay.
Sustained.
Judge, I'm requesting that a GAL be appointed in this matter. I am comfortable with an adjournment if my client gets liberal and reasonable parenting time. There is nothing to support that he shouldn't have contact with his daughter. And there's nothing to support that Ms. Hornbacher gets to decide unilaterally that he gets to see his daughter a few hours a day until she's comfortable with something else.
What are you proposing regarding parenting time again, Mr. Price? Is that 11 a.m. to 4 p.m.?
Yes, Judge, and if I might respond briefly, respect to the counsel arguing her motion just now, I have requested documents from her proving what she's saying, and I've not received them. I get it. I didn't have my appearance in until yesterday, but the bottom line is I didn't get those documents. That's why we have hearings. Right, so both parties can present their side in their evidence, not give hearsay through the attorney. My proposal, again, is for 2 days. We've got 2 weeks. 2 days, 11 a.m. to 4 p.m. for the plaintiff. Pick up at the child's preschool, drop off at the child's maternal grandmother's home. Give me time to get my responsive pleadings in and argue this properly so that both sides have an equal opportunity to present their case to the court. That's all I'm asking for. I don't think it's too much. 2 weeks.
Any other comment?
Yes, Judge. To address Mr. Price, I provided him a proposed order, a complete order, like this court is accustomed to with things like not disparaging the child, for his review. He was unavailable yesterday morning. I was not available last night. I didn't get his appearance till last night. So I don't customarily turn documents over to anyone without an appearance. These are medical documents. These are investigative documents with sensitive information. Mr. Price chose to take a case 2 days before a trial that's been scheduled since December 5th when she was served. My client shouldn't continue to be deprived of his daughter because Ms. Hornbacher wasn't telling the truth. She's indicated since the early November she's had an attorney. Yesterday was the first time Wednesday night was the first time I had a conversation with Mr. Price. That's it. So I don't know who her other attorneys were, but she was taking legal advice saying she should deprive my client of his time. We're asking if there's going to be an adjournment, that he have liberal parenting time pursuant to the schedule that we provided Mr. Price yesterday, and that if we're going to have a hearing, that's fine. But he gets liberal parenting time until that occurs.
Very well, thank you. Well, here we go again, and I'm not saying that lightly because we just had a hearing about this a moment ago regarding allegations of inappropriate behavior, so to speak. Allegations. Note I said allegations. This is a new file. This is fresh. We have another attorney that has just been retained in this case. I find good cause to adjourn the proceedings. I normally don't do that when last minute counsel gets aboard when there's a motion pending, but we're involving a minor child here, and we're also dealing with alleged denied parenting time, alleged. And for safety's sake, for purposes of the child in this case, the court will allow the parenting time of 11 a.m. to 4 p.m. on 2 occasions between now and the hearing that we will hold in 2 weeks.
Judge, is that 2 occasions per week or 2 occasions once per week?
I wasn't sure whether Mr. Price said twice a week or once per week.
I actually said twice per week for the next 2 weeks.
Twice per week for the next 2 weeks. Do we have times, dates that we can agree to, or is that something counsel can sit down and talk about, or do we need to hammer it out right now?
I would prefer we do it, Judge, on the record, so there's no confusion.
Okay, what are you proposing?
I am not available.
Well, I'm talking about the 2 days each week.
Oh, yep, just a second, Judge, let me pull up my client's calendar. But she'd like to take her on the weekend, so he would pick her up from the maternal grandmother's on the 13th and 14th of January.
I don't believe she's in preschool at that point.
That's correct, so he would pick her up at the maternal grandmother's.
Anything else? Yes.
Judge, he can pick her up today, but it would have to be at like 12 because he's got to get back over to Unionville or preschool or wherever she's located. But he could take her the 12th and the 13th and the 14th and the 15th. And that would get us through the next 2 weeks and we can come back that third week.
Mr. Price, is that acceptable to your client?
I heard the 12th and the 13th. What were the other 2 dates?
14th and 15th.
14th and 15th?
It'll be the second week.
Okay, and then we have, I'm assuming that's okay. Is that okay with you, Ms. Hornbacher?
It is okay with me, yes, Mr.
Okay.
Price. Chad has off, Mr. Hornbacher has off work those days, I'm assuming.
Okay. And then,
I don't know, but I would like to know that.
okay, I assume we're gonna be back here on the 26th, Judge?
We're just trying to do that now.
I am out of town, Judge. I am in a beautiful location far away from here.
February 2nd be the next available date.
And
That would
that
necessitate,
will work, Judge, but then we need to set up time that third week.
right?
And we can do the 24th and 25th.
24th and 25th of January work as well. Mr. Price,
Ms. Hornbacher?
11 a.m.
Our daughter has an appointment that I take her to with her counselor on the 24th. So I typically, Miss December wants me to take her to those appointments as of last that I spoke with her. So that is the 24th. Would another day be available? I would need to leave at 3:45 for that appointment. So either we change the 24th or it's an earlier drop-off day.
Judge, my client actually works with the same counselor with Elsie. He's happy to take her to that session. If the court's not comfortable with it, he can move to the 26th, but he'll likely be involved in that session.
Mr. Price, on behalf of your client.
Okay. Last I spoke with Miss December, she wanted me to continue taking Elsie to those appointments, but I don't know any different than that. So if Mr. Hornbacher knows that that's okay, then we can change that. He can take her to that appointment, but she wouldn't get home until about 6 o'clock that day. So it would be a later drop off, I'm saying.
So the 24th, Judge, what time is her appointment so my client can make sure she's there?
What time is the appointment?
Her appointment is at 4:15.
Did you say 4:15?
4:15.
4:15 on the 24th.
4:15 in Vassar, yes.
And my client is aware of where that location is because he's been there multiple times. Judge, so the 24th, the child will be returned after counseling, but obviously it will be after 4 p.m.
It's being returned to maternal grandmother.
Yep, maternal grandparents. And then for today, Judge, can we do 1 to 6? Because he's very clearly not going to be there at 11 o'clock, given that it's 10:31. And snow again is coming.
Is that acceptable, Mr. Price, on behalf of your client?
The 24th, 25th, yes. I pretty much lost audio, or didn't lose audio, but what counsel was saying at the end after the 24th, 25th was blurred.
Today, rather than just because of the timing, it's already 10:30. She's proposing 1 p.m. to 6 p.m. today.
Is that okay with you, Ms. Hornbacher?
Yes, I would agree.
Okay, so for today only, yeah, that's fine. And then a 6 p.m. return on the 24th, correct?
Well, whenever she's done, he'll bring her back to
Yeah,
counseling.
whenever the counseling session is complete.
Okay.
Does that cover it?
I think so, Judge. Can you refer to the front of the court in the same token so we can get this started? Ms. Schultz and I spoke this morning and she said.
Oh, for initial determination.
Yes, sir.
Absolutely, in all matters.
And then I would request that mom not be present at the exchange. This child needs to enjoy time. She's going to either be at preschool and my client picks her up, or she's going to be at grandma and grandpa's. And there's no reason that mom needs to be present.
No contact.
There's already a no contact order against the plaintiff. So
Oh, okay. I'm not aware of that.
Judge, would you like me to prepare the order?
I would, just gonna ask you,
Can I restate it on the record to make sure we're all the same spot?
please.
January 12th, my client will retrieve the child and keep the child 1 to 6. January 13th, my child will retrieve the child and keep the child 11 to 4. January 14th, my child will retrieve the child and keep the child 11 to 4. January 15th, my client will retrieve the child and keep the child 11 to 4. January 24th, my child will retrieve the child at 11, take her to her counseling appointment with Ms. Stember at 4:15 and return her when counseling is complete, recognizing we're in Michigan and weather could be crazy. January 25th, my client will retrieve the child and keep her 11 to 4. We are scheduled for a 2-2 hearing at 9 a.m. to continue with our motion. The exchange will be at the maternal grandparents unless the child is in school at the time. He will retrieve her from school. She gets out of preschool at 11 a.m. Mom will not be present during any pickups or drop-offs, and the entire matter will be referred to the front of the court for an investigation recommendation on all matters.
Does that sound right, Mr. Price?
yeah, that sounds right. I mean, like I said, there's a no contact order against plaintiff, so I don't understand the mom not being present, but it doesn't matter.
Okay, very well. Present an order to that effect, and we'll see everyone. We're adjourned until February 2nd at 9 a.m.
Thank you, Judge.
See you in person. Thank you.
Thank you, Judge.
You're welcome. Off the record. Parties are present. Can we have council appearances, please?
Morning, or good afternoon, Judge. Amanda Rodenbach on behalf of plaintiff Chad Hornbacher.
Jacob Perl on behalf of Terry Hornbach, CFP.
Thank you. Before we proceed in this matter, we had a comment in the chambers, and Mr. Pro, do you want to place something on the record of this?
Briefly, yeah.
Go ahead, sir.
The attorney that was dealing with this case previously, and that had dealt with the case, and some firm had been obtained, left our firm very quickly without telling anyone, which has put us in a situation where we're scrambling to a certain degree to make sure that we follow up all of our significant points. And I think it's at this point in time, I'm prepared to a degree, but I think that it would be in my client's best interest if she could get a little bit more time to discuss this matter with me, so that if we're going to go forward and there's going to be some significant potential changes that occur, that she has an adequate opportunity to address all of those issues. And again, it's a practical situation. I apologize for the situation, but I understand that we're prepared to proceed today, but we would ask politely and respectfully for adjournment, just on the basis of it being in the client's better interest.
Sure. And as a matter of fact, your office had reached out to our office yesterday requesting to appear by Zoom, right? Mm-hmm. Yes. Okay.
Thank you, Judge. Judge, I would say that Ms. Hornbacher has indicated for several months she's had counsel. I've been contacted by multiple, whichever follow-up. Ms. Hornbacher knew long enough ago that she advised the minor child's counselor that her attorney had quit. To date, I have received nothing from their firm. No contact that the attorney left, no contact that a new attorney, nothing. I've received nothing. And unless the rules have changed, firms are bound by their appearance. This firm filed an appearance, it's assumed that the attorneys in the firm are prepared to go forward. My client has been denied parenting time for months. The only reason he got to see his child is because this court entered an order. We cannot continue to sever the relationship with him and his daughter because his ex-wife doesn't like the fact they're getting a divorce. We simply want to have an order in place that gives him parenting time while the friend of the court works through it. The court remembers, we've already referred it to the friend of the court. We need something in place so that he and his daughter can continue to grow their relationship. I have a SANE nurse here, I have a CPS nurse here, and I have the child's counselor on Zoom prepared to testify. They have zero concerns with my client, and they found zero evidence that my client did anything wrong.
Well, this is the motion for adjournment.
I appreciate that. We'll object to adjournment.
Yes, I mean, at this point in time, obviously, opposing counsel has had a significant advantage in preparing and getting all of the witnesses here to testify in an effort to substantiate their claim that my client made these allegations up in an effort to undermine Mr. Hornbacher. But that's not the case that we have here in this incident. There were other issues that were preceding all of those issues that come up. But at this point, what type of ruling are we going to have?
Excuse me.
What type of ruling are we going to make?
Wait, there's an objection.
I'm going to object that they filed no documentation other than an appearance So they have no issues to plead before this court. Literally, nothing has been filed by their firm except an appearance the day after the last hearing.
There's also a motion to set aside the default that we're going to discuss. It's my understanding we hadn't filed, I don't know if it has been. I just got put on this recently, but there is an outstanding default that occurred based upon my notes after we had made contact with the opposing firm, which is disagreed, but at any rate, this was a very quick moving case. The default would be inappropriate. Good cause exists is, she did have another attorney she was working with.
Judge, I'm gonna
that
object
dropped
again.
her.
The default being filed or the being set aside is not before this court. That's not what
She's
the
talking
motion
about
is here.
pleading.
I'm sorry?
She's talking about pleading. We haven't filed anything for pleading
Yeah, there's nothing in the file regarding,
because the default hasn't been set aside yet, which you have to do. We have all those documents prepared.
right, it's not in the court file.
Okay.
It's not in the court file. It's before the court file right now is just parenting time. There's nothing in the file relative to, setting aside the default.
And
Nothing's been filed. There's just an appearance.
Well, it's
That's
something
our
that we're
position.
gonna have to address, and apologize we can't do it today on the basis of our associate not doing what we were supposed to do. It's unfortunate, we can go forward today, but the problem that we have is we're short-sighted. They get to call 3 witnesses that are gonna all undermine my client, and there's not gonna be enough time left to address all the significant issues that she's had with visitation, child support, and everything else that's occurred since June when he pled guilty to domestic violence.
Well, my position on it is very simple. It was scheduled for today. The firm is responsible. My concern is that the plaintiff has presented or is intending to present a number of witnesses subpoenaed today. We can leave the proofs open after those witnesses have appeared, see how things go, but we have to proceed today. And you did state as best you can, as best you're prepared, we're proceeding. So your objection is right.
Thank you.
Ms. Rokenbach, would you like to make an opening statement or do you wish to call witnesses? How do you wish to proceed?
There's actually 2 preliminary matters, Judge.
Go ahead.
One is there's some pretty significant physical examination records from the same nurse for the minor child.
I do.
Thank you. You may put your hands down. Ms. Schultz, anything from the front of the court? I understand you can tell me if I'm wrong. Parties have joint legal, joint physical custody, and Mr. DePatty has alternate weekends.
Mr. DePatty has parenting time pursuant to the 2016 guidelines. School year parenting time is alternate weekends from Friday at 6 until Sunday at 6. But it'd be week to week during the summer break and alternate hours.
Okay. Thank you. Miss, you are requesting a modification of parenting time. What is that based upon?
So that is based upon, I received a call after the Thanksgiving weekend from Mr. DePatty's sister saying that while him and my daughter and his mom was at her house, at the sister's house for Thanksgiving.
Okay, I'm going to stop you right there. That's from.
I have an objection, Your Honor.
I was just going to stop at this point. That's hearsay. Court cannot hear that.
Correct.
After being informed of that, I did contact.
Objection, Your Honor. She's still using.
I don't know what she was informed of. She was informed of something. That's all I know. That's how we're proceeding. After you were informed, what did you do?
I contacted Mr. DePatty and his mother through email and text message. Mr. DePatty doesn't respond to my messages, so I have had to include his mom on messages to receive answers about different things that come up. So I text them both regarding my concerns with what I was told and with what I'm asking for today. And his mom replied back that
I can't go to what mom replied.
so I was told that he was trying to get into a rehab program.
Okay, I can't, again, that you're told that that's hearsay. So what are you requesting?
That Mr. DePatty receive rehab services and that he not be left alone with my daughter until he has had these rehab services. And that Mr. DePatty not be under the influence of any drugs or alcohol or abuse prescription medications while he's around my daughter.
Thank you. Mr. DePatie?
I just object because the information she's using is based on hearsay. There's no proof of evidence or anything else to substantiate these claims. So I guess I'm concerned that she doesn't have the information firsthand. She's received it from a third party, which makes it hearsay.
Well, Ms. Beam, are you requesting then an adjournment of the proceedings to bring these individuals in to testify in the courtroom?
I guess if I have to.
Mr. DePatie, you're an over-the-road trucker, correct?
Yes, sir.
Are you even near Michigan at this point, or?
Yes.
Okay. Well, the court will allow an adjournment of the proceedings to get these individuals in to testify. It'll be your responsibility to subpoena them. But in the meantime, when is the next scheduled parenting time?
The next time would be January 26th. It would have been the 19th, but we have agreed to trade weekends due to my daughter having a birthday party that she wants to go to on the 20th.
Okay. So when will we have the hearing? Do you have a date in mind?
Do you want a special day or just?
Do we have a special date?
Because we can do it on the afternoon of February 2nd.
About the afternoon of February 2nd for the hearing. Does that work for you, Mr. DePatie?
Yes.
Okay. 1:30.
Yes.
February 2nd at 1:30. In the meantime, while we're thinking about this, and hopefully trying to reach a resolution, but Miss, what are your thoughts of continuing the parenting time, but his mother must supervise?
Yes, I'm okay with that. That is, to my understanding, what has been happening.
Okay. Mr. DePatie, while we wait for the hearing on February 2nd, any objection to continuing parenting time, but your mom has to be present?
I have no objection to that.
Okay, I'll order it. I'm going to order it then. Maternal mother must be with the child. Do you have anything else? Miss, do you have anything else? Sir, do you have anything else?
No, Your Honor.
Okay, thank you. We'll see you February 2nd, 1:30. Ms. Lyles' motion regarding parenting time. Both parties appear. Ms. Lyles appears in the courtroom. Mr. Keene appears via the Zoom application. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do.
Thank you. You may put your hands down. This is stated again, a motion regarding parenting time and travel expenses. Just a reminder to both parties, please do not refer to the child or children's names. Initials are appropriate if you need to refer to a child or children. Ms. Lyles, go ahead.
Okay. So I had filed a motion because I forwarded some texts that he had sent me over to friend of court, where he claimed that since he can no longer claim the children anymore on his taxes, that I should be responsible for 100% of the transportation costs to and from Texas. However, I do not agree with that. I think that the transportation costs should be shared, which is according to the friend of court guidelines, and it does state in the 2022 friend of court guidelines that each parent is responsible for picking up their child for parenting time. So I feel that what I'm asking the court is if this could be John's responsibility, the defendant's responsibility as far as to fly the children down to Texas and pay for their airline ticket. And then also to, as far as at the end of his parenting time, for him to get them back to the airport. And then I would pay for the plane ticket for them to fly back to Michigan.
Mr. Keene, your response, sir?
We have not used the friend of court guidelines at any point in time in this case history. And when I have been in court and used those guidelines, you have ruled against them. So we cannot go according to the friend of court guidelines because in your own rulings, we don't. And I have further objections to it, to me paying the cost because she receives money from me for childhood costs. What she does with that money, I don't know.
For what cost, sir? You said she receives money for you for what cost? I didn't hear that.
She receives money from me for childhood costs. And now she's going to court. Now she's going to court saying she's not going to pay for childhood costs. So why am I paying her for childhood costs? And it's all recorded through the friend of court. They can run you back months on payments that I've made to her for childhood costs.
Okay. Any other comments?
As far as, yeah, I have been receiving child support, but there was moments in time where he wasn't paying child support, for like up until, I want to say it was up to, because we had a hearing, I believe it was December of 22. I believe we had a hearing regarding child support, and I know there was like a certain amount of time he wasn't paying child support.
But at that time, he was still living in Michigan, correct?
No.
He was in Texas back then?
Yeah, he was in Texas. He didn't see the kids for up to 5 years.
All right. This is a motion regarding really travel expenses. Court is well aware of the policy, and it has been the policy of this court that when it comes to pick up and drop off, that it's the parent's responsibility who wants the parenting time to arrange that. It's the responsibility of the parent after the parenting time is over to make arrangements to get the child and children back. This case is no different. Mr. Keene has voluntarily moved to the state of Texas. I couldn't imagine what flights are. This is not a case of Ms. Lyles requesting that she not pay anything. She's willing to split it. That is the flight back from wherever it is in Texas back to Michigan. I think the motion is more than fair. The court is going to grant the motion, which means that the expense for getting the children and to make the arrangements to get to Mr. Keene would be his responsibility. And it is mother's responsibility once the child or children are returned to the airport by Mr. Keene, that Ms. Lyles is responsible for the flight back to the state of Michigan. That'll be all.
Your Honor, may I clarify one thing? And I know Ms. Lyles did not bring this up. Because we are dealing with flights for the children to exercise parenting time, is the court putting a time frame on when those flights need to be booked with notice provided to the other parent?
We should probably do that so
And
that we don't
would
have any
generally
issues.
go no less than 30 days in advance of the parent.
Would you please explain that to both parties? The court's going to order it.
What that means is, let's say that school releases on June 1st. We're going to make arrangements then to provide notice for summer break parenting time for the flight down by no later than May 1st. Flight numbers, times, those types of things. And it would apply for all periods of parenting time.
Thank you. That'll be all. Off the record. You're awesome.